I'm horrified. I'm horrified. I'm appalled. I'm disgusted. I'm angry. And I'm particularly infuriated that the entire world did not get to see this.
Even the notion that there would be even the perception of a cover-up in regards to an investigation involving 4 little girls is not only unsubstantiated, but, ladies and gentlemen, it strikes me at the very core of who I am. Any notion of a cover-up, any notion of us deciding the outcome of this, any notion of any connection to anything else is not correct. I've always said that the 2 sketches are simple sketches, they're not photographs. It's a piece of an investigative puzzle. And when we're all done with this, we're going to be able to meld the 2 of them together. And we're going to find that individual. That's what happened.
I have represented thousands of criminal defendants. And I can count on one hand the number of monsters in human skin that I've encountered among criminals, some of them serious, violent criminals. I saw more monsters in that courtroom today than I ever saw in an orange jumpsuit. And they had badges.
You're trying to tell me that I'm not making this fucking round shit up, Rick. It is what it is.
I'm done talking. Arrest me.
Happy to. Be fucking happy to, because I tried to fucking help you and you wouldn't fucking do it.
Oh, you're helping me.
21, page 215. He was tossed in the most secure unit in the state of Indiana, and he was treated just like the rest. That's what we heard. He was treated just like the rest. The rest of the convicted murders that were his cellmates. The rest of the convicted child molesters that were on that unit. The most heinous individuals in the state were his neighbors, and he was treated just like them. In fact, not only was he treated just like them, he was immediately placed on suicide watch. The evidence suggests that no human, no matter how strong, could endure those conditions for that long a period of time without having some kind of breakdown. Stripped of almost every necessity of a man's life and sent to a place where you have very few, given a suicide smock, basically a caveman gown. You have to eat off the floor, compete with mice droppings, ants.
And it wasn't solitary confinement. Nick and I do have a great relationship, but I do have to clear the air. I have never kissed Nick McClellan. Was
that a rumor?
There was media saying, or I don't know who said it, but the truth is, I said. When the verdict came down? Yes. I said, Nick, I'm so happy after the verdict came out. I'm so happy I could kiss you.
We're hearing this just for the first time in the defense case. These are the kind of goodies they have in the defense case. This is going to be good. And I'll tell you what's both kind of, it just surprises me, but it's also it's so disappointing. It's so disappointing. Is how many people left after the state's case was over. Today, no problem getting into the courthouse. It's the Nancy Grace phenomenon.
Downhill. Downhill.
Somebody fortunate to have coffee carts.
Some coffee shops around.
Was seated on the side of the courtroom where I was behind Rick Allen's family, so I did see Kathy react to the verdict. She was very quiet, but she certainly did have an emotional reaction. So she was in tears as the verdicts were read. And I saw Rick looking back in her direction, and I saw him ask his sister, "Is she okay?" And then I saw him mouth the words in Kathy's direction, "I'll be okay." So, still primary concern. Having just been found guilty of 4 counts of murder, his concern is for his wife and her well-being.
Everything in the Franks memo is an investigation that we did. The defense didn't go out and conduct their own investigation, so they have 136 pages of investigation that we did.
How about we hit that reset button and understand that justice in this country was served, and if you don't like justice in this country, go do another one.
I don't follow it completely, what he was saying, and I'll just briefly say, the solution to everything that he was pointing out is transparency. And the lack of transparency created all those things he was talking about. And there was no transparency in the state of Indiana.
Hey everybody! Excited utterance here. How are you? Good to see you all in chat. Good to see you all. It's a special day. It's a special day. Did you enjoy that intro? Did you? I might have spent a little bit of time on that yesterday. Just a little. Maybe a little bit more time than I intended to. I might have made it a little bit longer than I intended to. But I'm glad. I'm glad. I hope that it does justice to the subject matter and also to our special guest today, because she featured heavily in there. And as she deserves to, our special guest today, I haven't had her on here for about a year. And I'm so proud to have her back. Guys, we have an Andrea emoji today. I'm so pleased. And also, I'm hoping that we get to see some kitty cats as well, because she has some new family members that we've all gotten to know very well. Guys, today our subject matter is the appeal of Richard Allen. And I have covered this case a fair bit in the past. Richard Allen was convicted of the murders of Libby German and Abigail William about a year ago. And they, 2 beautiful young girls, around 12, 13, and they were brutally murdered in Delphi, Indiana on February 13, 2017. Actually, February 14. It was Valentine's Day, and it's very sad. The whole story is extremely sad and very dark. The whole case is very dark, and I don't know if it will ever be completely solved, but all I know is that there are some people who are at peace with the the guilt of Richard Allen, but there are a lot of people who aren't. A lot of people who aren't. And all I know is that he did not receive a fair trial. And the appeal for his new trial has begun. And I'm going to welcome Andrea in and get her to explain the appeal, because this is really where she shines. She is an appellate lawyer. I mean, she's shone a lot up until now, going to Indiana and spending a good couple of months of her life at sitting on those hard chairs and reporting on the facts of the case that we couldn't see because there were no cameras allowed in that courtroom. And that is an injustice in itself. But now here she is going out and spreading the word about what is in this brief, putting it into layman's terms for all of us. So let's bring her in. Hey! Oh, and Jude.
Hey, girl. And Gus.
Gus! Oh, you got two?
Gus here. He sleeps real nicely in the sort of cuddle position. I got Lilith here on my lap, but you can't quite see her. But at some point, she's probably going to jump on my shoulder. So, yeah, we got some kitties with us today.
Oh, look at that! I can pet that kitty. My goodness, Gus is a good name. I instinctively turned my head like it was you. I always do that when Dali comes in. I'm like, hey. Oh my God. We have a triple treat. We've got Andrea and two kitties. It is
maybe
so
more.
Sweet.
We'll see.
You never know. You never know how many kitties. Oh, wow. This is so great. And it's so nice that you have like these blessings come into your life. Like when the kitties came along, I remember you were like, what do I do? Now what? Now what do I do? And then it was just, and I don't think you knew whether or not you were going to keep them or if we were going to just keep just one or what. And then all of a sudden it was like, yeah, I can both.
Yeah, I've been very fortunate to have serendipity has played a big role in my life, and I feel like part of it is just that I've been open to that, and I'm actually glad that you bring up the blessings, because I can never give up another opportunity to appreciate the blessings that were the line sitters there in Delphi, who were the reason why I was able to do what I did and keep showing up into the court, because basically what happened was we had to be in line and then sit in court, and because of the just number of people that wanted to get in, you pretty much had to get back in line as soon as court was done if you were going to have any prospect of being able to do that. And so I made it a week and a half or something like that before I'm getting 2 hours sleep a night.
I remember. So you actually did the whole sleeping in line thing. You were actually out there in the cold. I remember. Yes.
Yep. Actually out there in the cold with the little chair and the hand warmers and stuff like that, trying to get, an hour or two of sleep here while you can. And it's just not a great environment for anybody's health. So I was so fortunate that, about a week and a half in, some folks, I think mostly on Reddit was where it kind of coalesced, but just took the initiative to decide we're going to organize line sitters for Andrea and for Lawyer Lee. She had line sitters as well. And they took care of everything for me. They scheduled it. They showed up. I just had to, get there in the morning. So I was able to get some sleep, and people saved my place. And it was so, I'm still kind of overcome by that happening, because it was so unexpected, and, just a complete blessing. There's no way that I was going to make it through the whole 6 weeks of that case at the pace that we were initially set. And of course, things then also got more difficult as time went on, because we also had to line up at lunch. So then we also didn't get to eat. It just got worse.
That first day, there was no lunch, right? I remember the first day. No
lunch the
lunch.
first day.
No. And like, okay, I don't want to start by throwing any shade, but you didn't have any assistants, right? Like you didn't have any
No,
right?
it was me.
Like,
it was just
it
me
was
there
just
doing my
you.
thing, minding my own.
No, you didn't have any like glamping equipment or assistants or anyone to like, get your coffee and like hold it up to your mouth or anything like that. Nothing like that.
No, I didn't have anything like that.
No.
I was completely on my own. And so that is, again, I'm always going to be grateful to the line setters for helping out and what they did. And I can never thank them enough for that. I could not have done it without them.
Oh, actually, is that true, Lindsay? There was no water in the court either at first?
Yes. Yeah, so there are a couple of drinking fountains in the courthouse, and that was pretty much going to be your only option to get water is if like during a break you could like work it out with the line. Hey, you're not going to like make me lose my spot if I go get a drink of water, William. Wow. People were cool about it eventually, but yeah, no water certainly in the courtroom. It was all limited to during breaks. So very unhealthy scene all in all.
Thank you for the 20 memberships I saw with Jackie. So sweet of you. And I got your email earlier too. Thank you so much. Hey, I just wanted to, on that note, before we get into it, the Judge Gold, most definitely, she did this for a reason, right?
Yes.
Like this whole idea of no accessible like water, food, making it really hard for you guys to be there. Like, tell us, what do you think that was all about?
It was absolutely deliberate. I mean, and that's in part because it would have been so easy to do it another way. But the hostility to the public interest in this case, which like appeared miraculously as soon as charges were filed, because of course before that public interest was fantastic and they wanted more of it so that they could get tips and stuff like that. But then charges are filed against Richard Allen, and the public interest suddenly becomes very threatening. And, bloodlust, I think, is how the safekeeping order characterized it. The most bizarre order, like I think I've ever seen written by a judge. It reads like a sovereign citizen type of pleading. And so that carried over, throughout the whole process. Really, we saw it so many ways that it manifested in the keeping documents off of the record, the exclusion of the cameras, with the one exception of when they had the ambush hearing, where the defense counsel was, threatened to remove themselves or she would shame them out there in the courtroom in front of the press. So no cameras or anything like that. She clearly wanted to discourage people from showing up and taking an interest. And if we were going to do it anyway, she was going to exact a cost from us. It was just very clear that that's what the deal was.
Andrea managed to write and file an original action on top of that. Yeah. So you wrote a writ of mandamus, or not a writ of mandamus,
I did. I petitioned for a writ of mandamus in the Indiana Supreme Court over some of these access issues. I tried to get access to the daily recordings of the trial so that those could be made publicly available and then alleviate some of this pressure to be able to get into the courtroom, because we'd have an alternative way of getting information about what was going on. Then I also challenged the procedure that Judge Gohl had adopted for viewing the trial exhibits, where basically she created this privileged access for the people with the media credentials to be able to come up after each court day and view the exhibits that had been introduced that day. We, the public, were not allowed to do that. So I challenged that on the grounds that there's not only like no legal basis to distinguish between the public and the press when it comes to access, but there's actually like quite a bit of law that says you absolutely cannot do that. You cannot create privileged access for the media. But they ultimately just waited until after the case was over, and then so it was moot, and then just denied my petition without comment.
Well, that was fairly normal, right? Like,
yeah,
no comment. Yeah. Okay, so I think maybe Andrea's cats are playing with your Starlink or whatever it is. That's probably my cats do that too. They just get in and take my internet away. Quite normal. All right, guys, let's get into this appellant brief. So I'm going to bring it up and just ask you some questions, and you can probably help me along the way. So let's go. Let's get into this. So, Oink. Alrighty. Alrighty, so Mr. Allen, it's now on him. So it's Richard Allen versus the state of Indiana, not the other way around. So am I right in saying that the burden's on him now?
I mean, more or less, yes. He's the one that has got to establish an error. Typically, he is going to have some kind of burden to establish not just that there was a legal problem, but often that it had some type of practical impact. It depends on the nature of the problem. Sometimes the state has the burden of disproving, that it had a material consequence. But by and large, he certainly is the one who has the burden to draw to the court's attention what exactly went wrong here and what was the effect of that.
Yes. So I watched your stream on this, and you went into great detail about how they've written a story here, and they've set this right up for the appellate court and gone right into the statement of case and facts, and they've shown how the prosecutors, they built up the way that the prosecutors made it so that Richard Allen was the only person that it could possibly have been. Can you talk about that a little bit?
Yeah, well, this was a theme that emerged from how they presented their argument and how they presented the facts that led into that. And they described it in terms of the state building the case against Mr. Allen. And that served to kind of frame the issues that they ultimately ended up presenting as how did they do that? And they did that through deception in how they got permission to enter his home and search for evidence. They did that through constitutional violations with how he was detained in solitary confinement there in Westville for months on end, psychologically deteriorated and so forth. And then they did it by taking away any reasonable opportunity on his part to either present an alternative version of events or to explain away why the prosecution's theory was incorrect. And so all of these things were necessary for them to be able to build this case against Richard Allen. I tend to put it in terms of generating a conviction. Like, what did they need to do to generate that conviction? This is what was accomplished. And so it just speaks to if you got a strong case, you don't have to do all the stuff. You can just rely on the strength of the evidence that you have. And this case was so marginal and always was so marginal from the very beginning that it speaks a lot of volumes about the extent that they had to engage in these, I call them shenanigans, but it's like, it's so trivializing a lot of what they did here. Just the outright deception is one that for me is particularly egregious because of the trust that we put in law enforcement and in prosecutors and so forth. To just, disregard that and mislead the court should be something that generates a lot of outrage. We'll see if they do.
The part that I thought was interesting, I wonder if I can find it. Actually, I heard you mention it on Brother Council's stream. It was the fact that, I mean, he did nothing different between when he supposedly self-reported himself to police when they were looking for tips back in 2017, and then when they arrested him in 2022, right? So he stayed at the same house, same job. He didn't get rid of his guns. He didn't change anything about his lifestyle. He didn't go to Mexico or anything like that. Like he stayed doing the same stuff. And yet they've gone and painted him as being, hiding amongst us. Yeah. And he self-reported. He said he put himself there. No, he did what any responsible person would do when law enforcement are asking for tips. He called.
Yeah, I mean the timeline. The timeline was that the girls were discovered, about early afternoon on February the 14th in 2017, and so law enforcement put out an announcement asking for anybody who had been out at the trails that day to contact them, or anybody who might have information to contact them. And so Richard Allen, ultimately, we found out tens of thousands of other people over the course of the years did just that. He immediately contacted law enforcement. He told them he had been out there on the trails that day. He gave them the outline of when he was there, what he did, who he saw, all of that type of information. He sat down didn't sit down, but he met with for an interview with a wildlife official, this Dan Doolin, where he provided his phone identification number. It's not the IMEI, but it's like a different type of identification number that his phone had. And so basically, it was very forthcoming about him being there and what he knew. They cleared his tip. They marked his clip as cleared, indicated that he hadn't provided any new information that they didn't already know. And that was that. And he went back to his job there at the Delphi CVS. He worked in the pharmacy. He was a, customer service representative. He had this, public facing job. He's right across the street from the Carroll County Sheriff's Office. Just back to complete life as usual, no observable change of pattern, nothing. Didn't apparently throw away his clothes, didn't get rid of his gun, didn't do anything that you might associate it with normal kinds of cover your tracks type of activity.
No, exactly. And the supposed Carhartt jacket that they said looked like his, like Bridge Guy's. He got that later.
Yeah, that's one of the issues that came up in the brief, is that there were several points that that law enforcement. So what happened then? Of course, they rediscover this tip in early 2022, and there's a whole story about that they don't get into in this brief, but it's rather sketch, the circumstances around this tip coming back to life. But anyway, they decide to take another look at Richard Allen, so they bring him in to re-interview him. And what ultimately happens, that is spelled out in this brief, is that during that interview, he provides them with all kind of information that they either completely misrepresent or have to distort and kind of try to talk him out of it, try to, get him to say something a little bit different to make it more incriminating. And he's generally not doing that. But so, for example, his clothing, he's like, he could have been wearing anything. He could have been wearing boots. He could have been wearing tennis shoes. He has a skull cap in his coat pocket. He might have been wearing black. He might have been wearing jeans. A lot of those types of things. Well, then that, translates in the law enforcement's representation of that interview as he said he was wearing the same clothes that Bridge Guy was wearing. And it's just, like observably not true. Like, this interview was recorded. It's there. You can watch it yourself. There's a transcript of it. He absolutely did not say these things. There's other parts of that too, like the route that he took to drive to get to the trails. This was not, I don't think, focused on so much in the appellate brief, but it came up very much at trial, how the interviewer is trying to put him on a specific trail, and having parked in a specific place, a specific route that he drove, and a specific place that he parked, and he denies it. He's like, I don't even like know how to get there that way, but that ends up as being part of the official narrative. He said he drove this route where we can, at least in theory, put his car on camera.
Speaking of cars on
the
camera,
other things he said in this interview, like the time frame, he says he was there from like 12 or 11:30 to 1 is a big one, because his story is that his family lives in a nearby town. So he had been visiting his mother, and they had all decided to go out to lunch, and he decided to go home instead. So he went home and got a jacket, and then went out to the trails and had his walk. So it puts us in a little bit closer to like an early lunchtime. And his estimate was sometime between 11:30 and 1. When it gets to, the official story from law enforcement, it's 1 to 3 or 1 to 3, 1:30 to 3:30. It's later in the afternoon to fit their timeline. So right from the very beginning, you start to see this distortion of what the facts are, in order to try to fit them into this law enforcement theory that needs to work in order for them to be able to pin the conviction on Richard Allen.
Well, they completely changed it, because the original tip that was cleared, hang on, let's see if I can find it. I'll share this instead. So this is the original tip back in 2017.
Mm-hmm.
Lead cleared, nothing new, phone info provided to ISP. I don't even know what does phone info mean?
It probably means his ID, the ID that he gave them, so that they could check it, because we know they had gotten the geofence warrant. They had gotten the tower dumps and stuff like that. So they had gotten a lot of different location information from different sources to be able to trace who was in this location at different times. So he provided his phone information. The lead cleared is a pretty strong indication they didn't find him there at any pertinent time. So he was cleared.
Yes, but this is also incorrect, because it says Mr. Allen was on the trail 13:30 to 15:30. That's not what he said.
That's not what he said in the only interview that we get to watch for ourselves, which is the one that he had with Mullen in 2022 after they revisited it. So this is the report from Dan Doolin. I think this is what came out of Orion, which was like the digital record keeping system that they use to manage all of this information. When this was entered, how it was entered, what it was entered from, we don't know. We don't have any of his original notes or anything like that.
Yeah. So this is the thing, like if he actually said back in 2017 that he was there between 1:30 and 3:30, you'd think that they would have followed that up.
Absolutely.
Right? And not have just put cleared on there.
And not just that, because
cleared on there.
Look, he gave them information that the three females, for example, you would be one with taller and long brown or black hair. You would be working to identify who all of these people are, because your ultimate goal is to identify everybody who is in the area over a specific time frame, and you can kind of map them all onto the trail at the times that they were there, and be able to kind of reconstruct what that whole afternoon looked like. So yes, there absolutely would have been a follow-up to try to identify who were these other individuals, to fit them into that, who are does his recollection correspond with the recollections of others in terms of like, were people parked there? Where were people parked? All of that type of thing. The details would have mattered a lot. So the fact that they didn't follow up on any of this, I mean, to me, it's bad. Even if, you know, he was in fact there at 11:30 to 1 or so. Just because of the importance of being able to recreate that entire day and the overlap between people coming and people going and stuff like that.
Yeah.
At best, it's incompetence. Apparently didn't do any of that.
Yeah. At best, it's incompetence. At worst, it's that they completely changed what he said.
Yeah.
Which is more.
Well, I mean, that's what it came to. I mean, clearly in 2017, they weren't thinking about accomplishing that. You know, but 5 years down the road, they sure were willing to take those kinds of liberties with the truth.
Now, speaking of liberties with the truth, so let's get back to the actual argument. So what we've got the argument split into three parts, and I wanted to talk about what the arguments are and the fact that when it comes to appeals, we've got harmless error and we've got reversible error, right? And this is what you do. Yes.
This is my wheelhouse. This is what I've been doing as a lawyer for the last 15 years. Yes, criminal appeals. I've done about 300 of them, I think, maybe 400. I forget. It's quite a few.
Yeah. And we're so used to hearing that, oh no, that was knocked back because it was harmless error.
Yeah.
Yeah. But in this case, I mean, to a layperson, it looks like there's lots of things here that are reversible error. Yeah. I don't know, Andrea. You tell me. Do you what if anything? I hate that term. What if anything do you think would be likely to be seen as reversible error in this brief?
Yeah, it's a good question, and this is one of those things that lawyers are all going to probably have different opinions about. But my view on this one is I'm pretty strong on the issue that he's got the best chance of winning a retrial on is the denial of his right to present a defense. The basic fundamental trial kind of fell apart, did not operate the way a trial is supposed to because of all of the things that he was not allowed to do. Just over and over and over again, he wasn't allowed to present evidence. The state was allowed to do things that the rules say they shouldn't have been allowed to do. He was basically stuck with this one-sided narrative presented by the state and not allowed to be able to challenge it. And so, if you kind of gag somebody at the defense table and say you can't contest what the state is saying, of course they're going to be able to convict somebody.
Okay, so that's the third argument. So the court denied Allen his right to present a complete defense, to explain the scene and impeach the investigation.
Yes.
Interesting. So actually, I would have thought it would have been the confessions, but that's interesting.
The confessions. So, I mean, I can talk a little bit about kind of the different issues and the complications that you deal with as an appellate attorney. With basically trying to get the recourse that you're looking for. And part of the issue is always that, okay, maybe I can establish an error. Maybe I can show that something was done wrong. But the question then becomes what happens? What happens as a result of that? What is legally the remedy for this particular type of error? And how far reaching were the consequences of this error? And so, for example, with the warrant, typical remedy for a warrant is you remand for exclusion at trial of the evidence that was improperly discovered as a result of the warrant. So that in and of itself kind of introduces a whole set of questions about, well, you know, where does that start and where does that end? You have kind of direct consequences of the warrant being exactly what they got out of the home on the day that they executed it. But you also have the downstream consequences of what only would have happened because of the fact that they found that evidence and then were able to capitalize on that to get other evidence or to take other steps in the case. So that starts to get a little bit more, what they say in the law is attenuated. And at some point, the court will say this is too attenuated. It's just too far downstream. There's too much in the interim that happened to be able to say that, that only happened because of this violation of the law. So that can become a real murky area. But then, as you also pointed out, there's the harmless error issue, because if the problem with the warrant is, okay, it allowed them to get evidence to prosecute, then they're not going to send it back to retrial if the evidence that they got in that search was nominal, like didn't really make a difference. There's overwhelming evidence of guilt anyway. Then they're not going to go through the formalities of doing that again. So that's the idea of harmless error. It's kind of like a no harm, no foul. It didn't really contribute,
make any difference. Yeah.
So
okay, that's interesting. I'll just ask a question about that before we go on, because I'm interested in this idea of the Franks hearing and probable cause, because it's come up in a couple of other cases as well. So, and because we had the Franks memo as well, right? So, and the Franks memo, large document, and it referred to some other parties, and I find it. I'd like you to explain, please, like, because as far as I know, Franks v. Delaware. Is about unconstitutional searches and the unconstitutional searches reaping results that could therefore be inadmissible.
So Franks very specifically is about when police include false information in their affidavit in support of a warrant, or they omit material facts in order to create a false impression. So it's basically about lying to get a search warrant. And procedurally, the way it's supposed to work is that I get a search warrant. I'm the trial lawyer. I get a search warrant in the affidavit. I have all the other discovery. I'm reading through it. I see there's something in this affidavit that is like flat out wrong. And I can prove that because I've got some other evidence. I've got a video of what happened. I've got my client saying what happened. I mean, whatever it is, I can prove that there's something not right here. So I file that in a motion. I ask for a Franks hearing. And in order to get the Franks hearing, I just have to present some kind of evidence that supports what it is that I'm saying. That, like, if you believe this evidence and it's credible, it contradicts what's there in the warrant, and it creates a problem for the probable cause that the warrant is based on. And as long as I do that, as long as I've got something that I can show you is a problem with this warrant, I'm supposed to get a hearing. And at that hearing, then we have all the evidence, right? Because the cops get to come in and try to justify, what they did. And if they've got some other evidence that they didn't mention or to talk about whatever, they can try to say it's not dishonest, or they can try to put it in context or whatever. So that didn't happen in this case.
No.
There was like the big Franks motion that they did ultimately have the hearing on, which involved, as you're pointing out, the third party culprit evidence and the ritual killing evidence, both of which were excluded, and he was not allowed to present at trial. But that was ultimately presented to the court in the context of they had done all of this investigation starting back almost from day one. I mean, back in 2017, they were starting to investigate this. We know now, looking at it after the fact, that there's not a single person that law enforcement ever conferred with who was like, no, it's not. It's not that. I mean, they talked to people at the FBI in the behavioral analysis unit. They talked to the professor from Tulane, whose name I'm now spacing, but Nick McClellan couldn't remember it. Wasn't sure we were ever going to find him again. There was a expert. Turco, yes, Professor Turco. Then there was a defense expert as well that they had hired, and so we now know all of these people have unanimously said, yes, this crime scene bears hallmarks of a ritualistic type of killing. These sticks appear to have some type of pattern. What they didn't agree on was what the meaning of these different things would have been. Like, if we assume that these sticks are meant to represent runic type of figures, what they would have been communicating by setting the sticks in this format. So that's really about the only thing that the experts didn't agree on. But there was not a person that they consulted with who was like, absolutely not, this isn't that. They left all of that out of their memorandum. They left all of that out of their warrant affidavit. And so this whole information
of their warrant affidavit. Yes. So
all out of the warrant affidavit. And so information that the court would need to put in context is Richard Allen, our guy, was material and was excluded from that whole process. So they had the whole Franks hearing initially based on that, but they had also asked for a Franks hearing just based on them getting a search warrant to go into Richard Allen's home in the first place, and essentially addressing these other issues, these other unfactual assertions that were included in that affidavit. The fact that they had two different descriptions of Bridge Guy that they had to kind of mold into one person. The fact that Betsy Blair's sketch and the Bridge Guy was inconsistent with Richard Allen. I mean, this guy. Yeah. So that was the actual sketch that they had, but they didn't include that. Yes. They didn't include any of this. And the fact that Betsy Blair's sketch was also different, very different from Sarah Carbaugh's sketch. And according to the state's theory of the crime, these are the same people. These are both Richard Allen, and they are also both Bridge Guy. But none of it was communicated to the judge that they don't look anything alike. So it seems kind of that they're the same person. As well. And then so this piece too, the description of the car that they had seen parked in the lot that the warrant affidavit is trying to attribute to Richard Allen's car, they didn't disclose to in the search warrant affidavit that Betsy Blair's description of the car that she saw would not fit Richard Allen's car that they're trying to say that he drove. She described it as a sharply angled sedan, like I think it was a 1967 Mercury Comet. I might have the year wrong, but I remember it was a Comet. His car, of course, looks absolutely nothing like that, and none of that was disclosed to the magistrate.
We only found this out after trial, after like lots of requests to Jody, the court reporter. All eyes will talk about this in chat. We couldn't believe it when we finally got some of the documents through, and this thing came through on this yellow piece of paper. This sharp-looking drawing. I was like, what the hell is that drawing? That looks nothing like anything to do with Richard Allen's car. So that was what was on the not on the warrant, but that was the sketch. Seriously?
That was her sketch, that she gave them to describe the car that she had seen. And they went with a search warrant affidavit that, suggested she had seen Richard Allen's Ford Focus right there, knowing that, her description doesn't match that at all.
And actually, I don't know if you noticed, but in the intro, I overlaid this photo because that was actually one of the cars that was parked outside the Hoosier Harvester.
Yeah.
And they're not that dissimilar. Kirk, not saying that was definitely it, but it could have been. Maybe. Who knows?
But you clearly see it's this type of a shape of sedan. It's not the hatchback. It's not the rounded. It's very squared. She had described it as like looking older, the older, boxier looking cars.
Yeah, it did not look like a Ford Focus hatchback.
Yeah.
Right? Not at all. Yeah, exactly. So anyway, what's that? I need to hear Hella say, "Who's your harvester?" Who's your harvester? I don't know. How do you say it? God.
This one was hard to say. I had trouble with this one during the trial. It's like a bit of a a bit of a tongue twister.
Yeah. So basically, Liggett completely made a bunch of rubbish up in order to get a search warrant. But the question is, does it even matter? Because is the appellate court going to just look at that argument and go, okay,
well, I think what it comes down to is if the court decides this implicates the statements that he made much later on down in Westville, would those be considered fruit of the poisonous tree, or would those be too attenuated? I tend to think they're going to think that they're too attenuated. And so what that means is that, okay, if we grant this request and we assume that all of this evidence from the search of his home should have been thrown out, it means they don't have the firearm and they don't have the, little stupid ballistics, which I don't even want to call it that, but the scientific nonsense that Melissa Oberg did. We don't have that. We don't have the clothing. We don't have the photos of him from that time, and we don't have the trophy bullet that they found in the keepsake box that I'm just here to say.
That thing.
After everything, I'm still like, I'm so sketch on that. I don't buy it. But, but whatever.
Yeah.
They don't have any of that. And so really what they have at that point is his statements later on in Westville. And so is that standing alone enough to convict him? It might be, it might be because we know that was extremely powerful. It was a very important part of the state's case. They had to rely on that heavily. I continue to see in like reactions to the case and stuff like that. Oh, but he confessed, and why would he confess? And so forth. So it has particular persuasive power, even when, we're talking about circumstances and the actual content of the statements themselves that we have in this case are like, just should not be given a lot of weight. But if a jury wanted to, could they convict him based on that? Yeah, they could.
Absolutely. I really want to talk about the confessions. I really want to talk about the confessions. Now, I don't want to bring up a certain podcaster, but I do want to say that there are a lot of people here who might have followed a certain podcaster and are aware that certain podcasters did say that Richard Allen was not tortured, and said that a lot, and also that Dr. Waller did nothing wrong. And two things about that. Firstly, I would like to, you were in courtroom, I would like to have you explain to us, firstly, what you heard and saw, and secondly, not just about whether he was tortured and his state of mind. You heard the confessions firsthand. You were there, but also Dr. Waller. I've tried to explain who she is and what she did, but her lack of ethics, how she was actually sacked from her role at Westville. I watched your stream and I'm a little disappointed that she's not brought into this as much as she maybe could have, I think. And I don't know whether that's what the reasoning for that is by counsel. Maybe you could talk about that a little bit too. Sorry, I'm asking you a lot of questions.
No, it's okay. With Dr. Waller, the issue with her is appeal issues can't really focus on interpretations of the facts, interpretations of the evidence to decide what do we think happened or what do we not think happened. It can't focus on things like, is this witness credible or is this witness not credible? And the reason why is because the law presumes that, number one, that's the jury's job. That's the whole reason we have them. And so if we're just going to like come in and second guess them, why would we even do that? But it just because they're in the position to be able to watch everybody, to take in the testimony, see how they're presenting themselves, put it in context of everything else. They're in a better position to make that type of determination than an appellate court that's just sitting there reading a transcript that doesn't have, you know, tone and intonation and facial expressions and things like that. So a lot of deference goes into the jury's decision about the facts and the jury's decision about who they believe and who they don't believe. So in terms of Dr. Walla, I don't think it makes a particularly good appeal issue to just like take issue with what she reported or what the jury thought about it. There would have needed to be some kind of legal hook, either to preclude her from testifying in the first place, you know, or to like undermine the foundation of what she was saying, meaning that like it's not, you know, it's not admissible for one reason or another. To me, the battle with Dr. Walla was really lost as soon as the judge ruled that the state was going to get access to her notes and to her records because you know, she's supposed to be his psychologist, and there's supposed to be a privilege there in your communications with your psychologist. And so the argued that, well, Richard Allen's putting this at issue because he's asking for, you know, the safekeeping order to be modified. Therefore, like we get to know all of the details of his mental condition. You know, is that an area they could have addressed in the appeal? I mean, maybe, but they have a lot to work with. They have to prioritize what the issues are. It's not such a crystal clear one that I can really see it being a slam dunk. And so if you've got like your list of possible things to argue, it's going to be one I think that you'd check off pretty early.
Dr. Walla listened to podcasts about Allen 3 hours a day while commuting to work.
She went to the bridge. She went to she like took herself on a field trip to the bridge. She talked on social media about the case. I mean, there's so many things that you can find fault with here. You know, not just in terms of like nice patient psychologist privilege you got here, Indiana, like basically none, but just with how she handled herself. Like if you're a clinical psychologist, you're not there to be talking about the facts of the case. Like you're not there to be an investigator and like eliciting information. It's clinically really not relevant. What matters is things like, you know, how is he presenting? Does he seem cogent? What's his mood like? Is he eating well? You know, what are we talking about in terms of how we can help him, you know, just live better and feel better and stuff like that. So the fact that she served as kind of this scribe is to me like inherently problematic, because that's not what her job is or what her role is supposed to be as a psychologist. It puts her automatically in a conflict of interest position with him because she's setting herself up to be a witness.
Something really bothered me in here, and hang on, I've lost it, but she had control over his comforts. So she had control over when he got to talk to his wife and mum, when he got access to a tablet, for example, just any sort of comforting thing. That was her decision.
Yeah, and they talked about at trial how whenever he would be put on suicide watch, they take everything. They take everything. They take your tablet. They take anything like movable out of your, and you get your turtle vest, and that's it. Which to me, it's like, this is so self-intuitive, or so counterintuitive, right? That somebody is deeply depressed, and so you give them absolutely nothing but the contents of their own mind to occupy themselves for, in his case, weeks, months on end. I don't know how anybody could characterize that as remotely therapeutic. But so she, being the psychologist, is the one who's going to be in the primary position of deciding, is he suicidal or not? So she has a massive amount of power in deciding, is he going to be on suicide watch where he doesn't get anything at all? Or is he going to be in the less restrictive where he can have his tablet and make his phone calls and all of that?
Absolutely. And look to this bit. In this harsh environment, Dr. Waller controlled all aspects of Alan's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could provide a new window and a tablet, or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Waller had ill intent is irrelevant. It is what Alan thought and what solitary confinement did to him, or would do to many of us. After confessing to Waller on May 3, he asked her his property back, and she indicated she needed more consistency. What the hell is that?
Horrifying? Isn't that horrifying?
What's going on there?
Yeah.
Right? And I actually listened back to one of your streams, and you said that you noticed something in one of his phone calls where, after Kathy or his mum hung up, you heard him say, okay. Like he was talking to somebody else.
I think it's mentioned in the brief somewhere. But yeah, there's a couple, he says something like, did I do okay? I mean, I don't remember the exact verbiage of it, but you can hear that there's somebody else, and Kathy actually calls it out on the transcript of one of these calls, where she's like, hey, is anybody in there with you? If anybody's in there with you, stop talking, don't do that. So yeah, there's real setup vibes going on here with Dr. Waller, and just how she behaved, how untherapeutic her relationship with him was, and the way that she injected herself into being an elicitor of facts. And in the context of the brief, they've cast this as the coerciveness of the situation. They basically argued that under these circumstances, his confessions, these statements that he made, and I should clarify, okay, when we say confessions, these things are so, I think I did it. Maybe I did it. You hear him talking himself into believing, like he doesn't know, but he's trying to get himself there, and he's trying to talk it through with his loved ones. And so we heard in the trial, phone call after phone call after phone call, where they brought up, where they like, he confessed in here, and every single one of those would be the same pattern. It's just this, hi, I'm calling to tell you I did it. Well, and they're like, no, you didn't. And you're like, well, but I think I did. I mean, I'm pretty sure I did. There's no detail. There's no, there's no like emotional salience with it. It's just like a thing that he's saying because he feels like he needs to say it. And it's
very strange.
The only quote unquote confession that has any detail is the one that Dr. Waller wrote in her notes, that there is no other corroboration at all that this ever took place.
And we don't have the notes.
Yes, correct.
She shredded the goddamn notes. Why did she shred
her notes? Her explanation was that she like once she entered what she needed to put into the computer system, that then she would shred her notes, and it came up during trial that is completely not the policy. It's not ethically what psychologists are supposed to do, but it didn't matter. That's what she did.
She's a maniac, this woman.
Yeah.
Okay. Lindsay Hendricks asks, were all 61 confessions played or shown in court?
So I didn't count, but the thing you got to understand is that the overwhelming majority of these confessions, there's no corroboration of them. They're not recorded. The ones that are recorded are the ones that are on the phone calls. And so, yeah, we heard, I want to say 6. I think it was 5 or 6 of those phone calls. Everything else is reported by somebody who says, "Oh yeah, I heard that." It's written in the notes from the suicide companions or from the guards who were outside his door or from Dr. Walla.
Yeah. And also with these suicide companions, I only found this out listening to one of your streams the other day. They're not all guards, right? They were prison inmates.
Yeah, they started off with using prison inmates as quote unquote suicide companions. So you basically, like, we already all know the issues with jailhouse snitches and the incentives that they have to just say whatever might get them some kind of advantage in their own situation. These are the people you're going to station outside his door and be like, "Tell us everything he says, wink, wink."
Yeah. What? They just had inmates outside his door, supposedly making sure he doesn't, off himself. And they're just taking their word for whatever it is that he said. But they weren't the ones that testified. The ones that testified were, like, via hearsay, some guards.
Yeah, so they didn't bring in any of the inmates to testify. They just got all that in through the notes. But they did bring in the guards. They brought in the prison guards to testify. God, what a bunch of, that was the day. That was the day when I talked about the monsters and human skin. Like, just what a bunch of like dumb psychopaths in one place. There was like one guy I remember that seemed like maybe he had a little bit of a conscience, and he was one who had left. He had left IDOC. These guys were horrifying. I mean, just dead inside people.
Wow.
Sadistic. Not good.
So I do want to touch on this Odinist guard thing for a minute, because I know that there are some people who just think that this is conspiracy theoryville. That come on, like, once you start bringing in the Odinist thing, and then there's Odinist guards, and there's guards with Odin patches and Odin tattoos, then now you're just being silly, guys, and he must be guilty, because when you start bringing all that stuff in, then you're all a bunch of nutters. What's your take on this?
They saw the guards, like, with the Odinist patches. It's here in the brief, not the Odinist guards, but the way that the inmates would yell at him, go kill yourself. It's in, like, one of the videos that they didn't allow them to play the sound. So they have a whole narrative of what it was like inside Westville for Richard Allen, that the state has, not just contested from day one, but they've insisted it's all a lie and that they're fabricating this. And the more that comes out and the more that we actually get to see, the more that corroborates exactly what the defense has said. This is what it was like. Odin guards, they witnessed them. The defense team saw them with the patches on them. If I remember correctly, didn't one of them even submit a declaration that he'd had these patches? It's just this wasn't controversial. It was a real thing. They very much did.
Yeah. Look, I believe it's real. It's one of those things that sounds so fantastical that it's really easy for normal people to look at and just go, that sounds ridiculous. And that just goes to prove that he's guilty. Because why would you bring up something so stupid? And I get it. I get that it sounds silly, right? But it's, unfortunately, there are crazy things that happen in this world, right? There are. And
the the thing that bothers me about it just is that if it's so ridiculous, then let him put it on. Let him put on the defense. If it's that ridiculous, then the jury will laugh him out of the room, and they'll have no credibility, and he'll have had the chance to make his case. To me, it screams that it's not ridiculous. There's in fact a ton of evidence that supports it, and that's why they were so afraid of it. If it was as stupid as they say, they would have been like, great, go ahead and put it on. Here's the name of Jeffrey Turco. Put him on the stand. It's insane. The jury's going to hate you. But they didn't do that, did they?
No, they didn't. Exactly. That's right. If you think it's so silly, then why are you suppressing it? Right?
There's the old saying, I think it's Napoleon, never interrupt your enemy when he's making a mistake. Like, why would you get in the way?
Exactly.
You think it's a big mistake? Let him make that mistake.
Totally true. Totally true. I remember when the Franks memo came out, and like the first reaction to it is like, what?
Yeah,
no.
That was a wild read. It was a wild read.
And it seemed so ridiculous. But I remember sitting on a plane to a dance festival and just reading it. And the more you read it, the more it was like, wow.
Mm-hmm.
Huh. Okay.
It was very compelling.
And
I mean,
it was.
The motion was, I mean, there, you know, I can always critique, you know, legal work. And there were things about it I didn't particularly like, but I thought it was quite persuasive in that, just voluminous information, the sourcing of what they had, the fact that this all originated from law enforcement. This was always law enforcement's theory. They were the ones who developed it. They were the ones who got the evidence that supported it. They were the ones who never disproved it, never eliminated it until, you know, apparently they just decided to let it fall by the wayside because we got a guy that we can't tie to Odinism that we want to pin this on.
You saw Nick McClelland on Hidden True Crime saying it was the Franks memo was all investigation that we did.
Yep.
He sat there and he said it. It was all investigation that we did. And he's right.
It was. I mean, such investigation as it was.
It was. And FBI, like there was 2 FBI agents as well, one of them who's dead.
Mm-hmm.
But they decided to turn their back on those FBI agents.
Yeah, and you know, and part of it too, I have to wonder if you know, the part of the reason why the Odinism, you know, they fought it so hard to come in is because then we have to talk about how the law enforcement handled that investigation, and why we've got to start calling out the discrepancies between how you just sort of take the word of Brad Holder and Elvis Fields and Patrick Westphal. And Richard Allen, you not only don't take his word, you got to like kind of twist it and distort it to make it into something else that fits. But we're going to be talking about blown alibis that you didn't investigate. We're going to be talking about, you know, people saying extremely incriminating things that you didn't follow up on, that you didn't try to corroborate. We're talking about phones that you didn't look into, data that you didn't get, location information, like all of these potential roads you could have gone down that you went down with Richard Allen. Why didn't you go down it with these people who, by the way, have an actual contact with the girls? They have an actual connection with the girls. You know, Brad Holder's son is dating Abby. And that was something that we learned from this brief. We didn't know from the trial. Abby had texted him that day saying, meet us out on the bridge. And he said he can't. So they knew where they would be. I mean, yeah. The counterpoint between if the jury saw the weight of what there was for those people that they just didn't bother to follow up on, it's going to inevitably raise the question, well, but if not them, then why this guy, Richard Allen, that doesn't have anywhere near the strength of the evidence against him?
Absolutely. Velveteen Bilby asked a really good question. Can anyone please tell me, if he gets an appeal, does he get a new judge? Yeah.
Nope.
What?
Nope. Mm-mm. Nope, not normally. The general idea is that they kind of want there to be continuity as much as they possibly can, because they don't want new people to have to get up to speed on the case. So ideally, they want the same defense lawyers, they want the same judge, they want everybody to be the same. So unless there's some basis to disqualify the judge, and unless they ask to disqualify the judge, which they haven't done in this appeal, and just based on the errors that they've raised. Well, based on the errors that they've raised, there isn't really a good argument for it. Just the fact that the judge has made mistakes isn't grounds to remove the judge. You have to prove actual bias. Now, is it hard for me to see that? Not in a million years. But you run into these problems with the legal doctrine where they basically say, the way that the judge rules in court can't be used as a ground to challenge their partiality. To me, it's like it's nonsense, just kind of in principle, because that's how bias manifests. It manifests in court with bad rulings against you, and I can prove that. I can't prove what's in somebody's mind or what's in somebody's heart. But they don't want it to be easy to disqualify judges. And so, to be able to prove bias typically requires a specific kind of conflict of interest, that they are they're related to somebody, they got a financial stake in the case or something like that. They've got, information, they know something because of their own situation. They know something about the case that isn't necessarily going to come in at trial. Things like that. So it has to be a really egregious situation to justify moving to disqualify the judge. We already know they tried it when they had some pretty bad, they had some pretty bad information back when they took that up to the Supreme Court, when the defense lawyers were thrown off of the case, and the Supreme Court said, no, we're not going to do it. So I don't see that they would have had a better chance of getting that accomplished this time than they already had.
So it's not enough that she declared her bias in the order calling defense reckless and grossly negligent.
I don't disagree with you. I really don't. But it's her order. It's her order and her finding, and so it's largely insulated.
Yeah. But the fact that she never gives any reasoning for her decisions, like she never.
Yeah, okay. Not illegal.
Okay.
Not illegal. Wow. There's strategic reasons sometimes why judges will do that. It's from a practical standpoint, it's not a good practice for having like smoothly running court processes in front of you, because talking things out and getting people on the same page about here's what the rules are and here's what the thought processes are and things like that tends to be the best way to do business. And then there's no guesswork, there's no misunderstandings. Everybody's on notice about the expectations and so forth. But when you put your rationale on record, then that can be challenged more easily in an appellate type of context. If you don't put any type of rationale, then the Court of Appeals is going to guess. And when they're guessing, they're going to assume that it could have been anything. And so if there's any possible way that what you ruled is correct, then they're just going to assume that that's what you went with. So it can be strategically smart for judges to not state the basis of their rulings, even though, like, as a practical matter, it can turn their court into a bit of a morass.
Wow. Okay. Let's talk about the third area, which is the area that you say is the most likely to be reversed. So the court denied Allen his right to present a complete defense, to explain the scene and impeach the investigation. So the court committed reversible error by excluding Blair's sketch of Bridge Guy. So we looked at that sketch. The court committed reversible error in excluding Tobin's testimony. Can we talk about that? So let's have a look at page 91.
Yeah. So Tobin was the defense's PhD metallurgist, and they wanted to present him to counter the testimony of Melissa Oberg about the The spent shell casing that she produced from Richard Allen's gun matched the unfired cartridge that was lying on the ground at the crime scene that may or may not have anything to do with the crime at all, but was there, is a purported link, I guess. He was there to undermine both her process and just the general field of these types of tool mark comparisons and in general. This is an area of forensic science, I have to irony quote it, that has been under criticism for decades. A lot of different scientific methodologies have in this particular framework when it comes to court evidence and investigations and stuff, because they're largely guesswork. They aren't very well validated. They're based on a lot of assumptions that aren't always true. They don't have enough foundation to be able to give like statistical strength to the conclusions that are being reached, which is like a kind of a hallmark of good science, is how certain are you? And you can put a number on it, then that's kind of the gold standard.
Yes.
So tool mark analysis has all of these general problems of, we don't have good validation about how do you tell marks that are distinct, that a gun will produce from marks that are the same, any gun by that manufacturer would produce the same marks. The standard itself that tool mark analysts rely on is it's circular and subjective. It says if once you have your comparisons, you can determine that there's a match if there is sufficient agreement between the two things that you're looking at. What is sufficient agreement? It's completely undefined. It's up to the analyst to decide for themselves whether they think it's sufficient or not. So now you got a problem with replicability and falsifiability. Like how do you disprove that? How do you get a universe of ballistics examiners to be able to all look at the same thing and reach the same conclusion? So it's a very poor methodology. It's been criticized in lots of places. The Maryland Supreme Court was kind of a landmark decision, the Abrukwa decision a couple of years ago, where they basically said, you can't draw conclusions about identity from this methodology. You cannot say that this firearm produced this shell or this shell casing or this bullet or whatever, because you don't have the scientific basis to be able to say no other firearm in the world could have produced that. So what you're allowed to do in Maryland is just testify it's consistent with the marks that this gun would produce. Oregon followed up, I think, just last year. They have a similar decision now as well. So it's been under fire for a long time. These are not new criticisms.
Under fire.
Yeah.
Sorry. Couldn't help it.
He's going to testify to a lot of this stuff, and he got excluded. Gohl said he's not qualified. He doesn't have the right credentials. He didn't do the type of examination that she thought he should. A lot of her factual predicates were just wrong. Like she said, he didn't examine the Melissa Oberg's work. He did, in fact, examine her work. He is familiar with the AFT standards. He's testified as an expert almost 300 times on exactly these issues. So that's the issue with Tobin. He didn't get an opportunity to educate the jury that this is pseudoscience, basically.
Because didn't he say? Did he say paternity test? Who said paternity test?
This was when Jerry Holman was interviewing Richard Allen the second time. So the first interview, they got the warrant, they went and searched his home, they got the gun,
right?
And then Melissa Oberg did her magic voodoo, which, by the way, for folks who aren't as familiar with this case, before Richard Allen's gun, she had already looked at other guns that they had recovered in their investigation, and she had not been able to exclude those guns as having produced these marks on this bullet that was found at the scene. But then once she gets Richard Allen's gun, according to her, and then she does this test with it where she's comparing a spent shell casing to an unfired cartridge. So they've gone through different processes in the firearm, and says, oh, no, now now they match, and now it's definitely Richard Allen's gun. So then Jerry Holman goes back and interviews Richard Allen a second time, and he's got these results, and that's part of his ammunition. You see in his ammunition, and that's what you see in the course of the interview. That he relies on very heavily. You know, he's using the read technique where they're trying to confront you with, like, you know, evidence that they have, and a lot of times they're lying about it and stuff like that. But this is one of the things he says during that interrogation of Richard Allen is, oh, that we've got the bullet and it matches your gun and it's as good as a paternity test. It's as accurate and reliable as a paternity test, which it 1,000,000% is not. These are not even in the same universe.
Guess what, Andrea? I don't know if you've seen this, right? But at CrimeCon, you know how... Oh, yeah. Okay.
I tried to avoid CrimeCon. Like, what a shit show. Sorry, but I'm just going to say
like, really, I thought you would have gone. I thought you were really first there. Jokes.
Yeah, let me give them all my money so I can have my little booth. Yeah, that's never gonna happen.
Yeah, right. No, I thought you'd be guest of honor getting a Clue Award. Anyway, yeah, guess this, right? So at CrimeCon, McClelland said up on stage with Susan Hendricks and that, oh yeah, it's like a paternity test. Yeah,
he said it there too. That's insane.
Yes, he
That's
did.
Insane.
He did. I was watching because you know how in the intro part I was that thing where Jerry said, "Oh, I've never kissed Nick McClelland."
Yeah.
That was at CrimeCon. That was him up on stage. Yeah, at CrimeCon with Susan Hendricks and that. Yeah, it was in that little.
Yeah, it's ridiculous. Like, nobody who's got, you know, a greater than 80 IQ and understands anything about either of these two processes is going to say that they're remotely equivalent. They're not. They have little to nothing in common. The only thing they have in common is that they're both pattern recognition techniques, and one of them operates on a very precise, very strongly validated molecular level with a lot of statistic evidence behind it. And one of it is somebody looking through a microscope and saying, good enough.
Hella, did you see the clip T and Sleuthy played? I might have to look at it backstage while Andrea's talking and see whether or not do we want to go there? Do we want to go there? I don't know.
You can bring it up. I won't. If I can't handle it, I'll close my eyes. Richard Allen is not the father.
It's not the father.
Do the not the daddy dance.
Not the daddy. There is no problem. NM does not have an 80 IQ. Well, I mean, somehow we managed to pass the bar, but
Nick wasn't the idiot. Nick is quite smart, and that's what makes it particularly egregious what Nick McClelland did, because he does definitely know better. Now Jerry Holman is about as smart as a bag of bricks, so he might very well think it's as good as a paternity test, and it's you just put that on par with all the millions of other things that Jerry Holman doesn't know.
They also said RA wasn't in solitary at CrimeCon. It was one man's cell. And Susan was like, he even had an iPad, even though he didn't have his tablet from April to June. Let's talk about the tablet, right? So didn't it have like Candy Crush on it?
No, it's not an iPad. This is a Securus tablet, and so at least I think it's Securus. I forget now off the top of my head. There's like a few big contractors in prisons around the country that provide these different services relating to like the phone calls that you have to pay an arm and a leg to be able to have, and then these entertainment services that you can get. And so it's the tablet typically, it doesn't connect to the internet. Nobody is connecting to the internet inside of a prison. That's one of the security things. So it's all just whatever is locally loaded onto that tablet. And so it can typically have, it might have things like games. It might have something like Candy Crush. You can typically get music. You might be able to get a TV show or things like that. Just different entertainment things that have been, pre-screened by the prison to decide that they're okay, for inmates to watch. All of this costs money. So you have to have money on your books to be able to get access to any of this stuff. Which may or may not be available depending on the circumstances.
Hey T, how's it going, mate? How's it going? Let me have a look.
Just bring it up. Just show everybody. Why not?
I trust you, T. I trust you. Oh my God. Oh my God. No.
No. Oh no.
Hey.
Oh man.
Hang on. There was no AI or hacking involved in this. None.
Oh God.
That was DB, wasn't it? It was DB.
It had to be. It's very high quality.
Jesus Christ.
Oof.
No! Stop.
I can't. I'm going to have to.
So look at the look on his face. Like, look at the look on his face as he's just about to grab him. Like, look at that. Well, I mean, see, cops are allowed to lie, right? And, like, clearly Jerry lied when he was up there talking to Susan Hendricks. He said, like, no, I've never kissed Nick McClellan.
Yeah, I mean, this was one of the things I talked about on my stream. I think we talked about it on one of the interview days. It was that day when I was pissed off because of how they were read-techniquing him and stuff. And that's one of the practices of the read technique very specifically is to lie to the person that you're interrogating. And Jerry Holman had been testifying this day, and he talked about how, we're allowed to lie as part of our investigation. And so, we're going to hear things during this interview that aren't in fact true, but it doesn't reflect badly on him or anything like that because it's legitimate police strategy. And the problem with it is that, yes, there is some truth to that in that legally speaking, police are allowed to lie to you.
Yep.
You have to really question the moral framework that you operate in when lying it becomes something routine, something that you calculate in terms of its utility. Is it going to help me get to where I need to go? It's not a good state of affairs to have police officers kind of steeped in this mindset of, I might as well freely lie because we count on them to be scrupulously honest when it comes to things like writing their reports and submitting affidavits to court and things like that. And so this idea that you can just have all of this leakage, with dishonesty, and that you're somehow going to be able to compartmentalize that from everything else that you do in this process, I don't think that's realistic. It gets them in the habit of lying. And once you're in the habit of lying, you're going to lie. You're going to lie more, and you're going to lie about more things. So
you said this last year when you were reporting back from Delphi, like they start to get into this mindset of lying, and then they start to feel like they're doing the right thing because it's going to put the person away. And they're so convinced that they've got the right guy.
Yeah, and they're convinced they're the good guy, right? I'm the good guy. I'm wearing the white hat. So whatever I do is good. And so even if I do these terrible things like, torture this guy in solitary confinement, lie about the evidence and so forth, it's all good because I'm good. It's this very self-referential virtue ethics that a lot of these unethical cops and prosecutors I can see it in how they practice. Like they don't consciously think this stuff out. But you can just see it in how they operate.
Yeah. It's like it's this confirmation bias that keeps going on and on in their head that we've got the guy, we need to put him away, and whatever it is that we do that leads to that end result is kind of fine.
Yeah.
And he deserves it anyway because he murdered some girls. So fuck him. Like whatever happens. And yeah, well, I mean, I'm kind of telling the truth. if I have to just twist it a little bit, then
it's
no
truthy, as Stephen Colbert would say. It's truthy.
Yeah, it's a bit twisty. It's a little bit twisty, but we'll get there in the end. But people should be applauding me, and then they go to a place like CrimeCon, right? And P.S. at CrimeCon, everyone was applauding them, and they were happy. And the thing is that they were actually saying that it's really nice to be here, and we're not getting all the hate and stuff that we get online.
Mm-hmm.
And it's very unusual because we get so much pushback. There's been so many trolls and haters, but here we're actually getting like some appreciation for all our hard work.
Well, of course, because it's a curated audience. I mean, by definition, the people who are going to pay money to show up and hear whatever dumb shit is going to come out of Jerry Holman's mouth is going to be a friendly audience. So it's self-selected for that.
Yes, exactly. They wouldn't let anybody in who felt any different. And if they did, they'd probably get kicked out, or like the rent-a-cops that are there would kick them out. But we won't talk about that. So the court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. So what's this hearsay?
This was Cecil doing the Google search out in the hall after the defense's cell phone forensics expert testified that from her review of the extraction, there was evidence that a wired set of headphones had been plugged into Libby's cell phone at about 5:30 in the evening and then unplugged about 5 hours later. And so this is very devastating to the state's timeline because they have Richard Allen leaving the scene at like 3:30, 4 o'clock, something like that, not a whole lot later, and never going back. So nobody has, any business out here at this point in time, messing with the phone. Plus, we've got the search crews out there at this point. The search is out there like. It's just it's going to be a difficult story to reconcile with the state saying the girls are there in the same place since 2:30 in the afternoon on the 13th. Yes. So Cecil, who was the state's cell phone forensic guy, he came back on the stand in rebuttal and testified, well, I went on Google and I found some user forums where they said that sometimes dirt or water getting into the headphone jack can make it act like there are headphones in. So this is classic hearsay, just random shit that you Googled online. You're just acting as a mouthpiece for it. You have no, basis for evaluating this information. It's kind of on its face, doesn't even sound really that pertinent because it's talking about user experience and not interpreting forensic data, forensic downloads and stuff like that. Yeah. So this is so classically hearsay that I've pointed out a few times. I've literally won an appeal on this issue on a law enforcement officer. Googling.
Oh, really?
Yeah. Looking up online information and presenting that as opinion testimony. It came up in a case I had where there was a dispute about the value of a piece of property that had been stolen in Washington. Depending on what the value, it's either a felony or a misdemeanor. So he testified. I looked at all these different websites to get the value of this. It was a computer. And lo and behold, of course, the value is above the threshold for it to be a felony. So I challenge that on appeal. It's absolutely classic hearsay. What people say on the internet is out of court. It's being offered for the truth of the matter asserted. It doesn't fall within any recognized hearsay exception. It's not admissible evidence. And I won on that. I got the conviction.
Nice.
Reduced to the misdemeanor basically because of that. So that one to me is an easy no-brainer. Like, of course it's hearsay. The defense is definitely going to win that. The issue is going to be what's the kind of downstream implication of it. What do they do with that?
Right. So, I mean, could that actually be a overturn of the conviction, or
Yeah, so pretty much
What's
all
not
of
that
these
far.
errors, these are errors affecting the evidence, that was admitted at trial. And so if that evidence hadn't come in, or the stuff that he wanted to introduce that he wasn't able to, if that had come in, the court's going to be looking at, does that create, is there like a reasonable likelihood that the outcome would have been different if they had had this opportunity to be able to do that? So one of the things I talked about, I don't remember if it was on my stream, it might have been when I talked to Peter Tragos about this appeal, but a lot is going to depend on the court's attitude towards these errors. And do they look at these things real isolated, real individually, like bit by bit by bit? This hearsay error standing in and of itself isn't going to be, dispositive. Or are they going to potentially look at all of these things cumulatively? Like if there's multiple problems here, which I think there are they going to look at that effect in total and, evaluate whether the error was harmless in that way? So that could very much have an impact on the ultimate decision that the court reaches.
Yes, because, I mean, as you say, point 3, the court denying Allen his right to present a complete defense to explain the scene and impeach the investigation. You think that this is probably the strongest one?
I do. I think this is the strongest issue. I think it's got the ones that legally speaking are the clearest. It's not like the one we just talked about. It's really not particularly debatable. It's okay. Okay. And I think it's got that going for it, but it's also it's just also got a little bit of kind of appeal to it in the sense of the fix makes sense. The fix is proportionate. If you accept this underlying kind of premise that it wasn't a fair trial, then giving him a new trial, fixes that, and it takes you kind of out of the universe of like, well, am I like super second guessing the jury? You're kind of giving the jury an out for like, yes, I'm not going with your decision, but it wasn't your fault. You were just relying on the information that was presented to you. So you're not like condemning the results of the process in that sense. You're just acknowledging this wasn't right and there's a do-over. So I think that it's an easy one because you don't get into these questions about, well, like how attenuated is the problem, and some of the other issues that come up there.
Okay, so let's put that aside for a second and go, okay, so let's say that if they were to grant it, what is it a complete start over in that they could that the state could go and put completely new evidence against Richard Allen forth, and also the defense could put a completely new defense forth?
So I mean, yes and no. You're not bound by whatever your strategy was in the first case. You're not bound by the decisions you made about who I'm going to call or who I'm not going to call and things like that. You get to remake all of those decisions. But all of the previous evidence is potentially going to be admissible and could be used potentially to impeach you if you try to change your story. Like if the investigators get on the stand now and they've got a different explanation for X, Y, and Z, defense counsel is going to be able to pull up this transcript from the old trial and be like, yeah, last time you swore under oath to a jury, you said this instead. So they're not, their hands aren't tied, but they do have some practical restraints in that sense.
Okay, no, that makes sense. I want to ask one specific question about you guys are going to pick me up on my pronunciation of the Hoosier Harvester footage. It's not really footage, it's some stills. There's a particular still of what supposedly is, hello, I'm going to bring my cat in. Oh, no, not, he's gone. Of what is supposedly his car, and I don't believe it's his car, but of the Subaru. And they have taken one still and they've blown it up, and I know that they have altered it, to try and show light coming into the spokes or the hubcaps of this of the wheels of this car. I know this because I've done a adjustment on it myself to make the same alteration happen, and I can make it look like light is coming through that particular frame and get the same result. And I made a video about this, and I can't see it in the appeal. Not that it needs to be in the appeal, but I hope that if the state brings this piece of evidence in again, that the defense jumps on it, because I believe that it was actually kind of important to the jury. I think probably was important to the jury, from what I hear from people who were watching in the gallery, that it did, like, people believe that showed that he was there at that time. So
so they'll have the opportunity, if it went back for retrial, there's a lot of different ways that it can go. But it's not going to happen right away. It's not like it gets sent right back down and now next week you're going back to trial. There's a whole kind of timeline and process that they're going to have to go through. And so it's not off the table that they, get to continue to do investigation. In fact, the argument is that ethically they're, obligated to continue investigating up to and including through the trial. So they have the opportunity, by all means, to look into stuff like that. Now, we run into the same issue with Goal that we had in trial number 1, which is that she didn't want to provide funding for experts and things like that, like analysis of metadata and photo alteration and things like that are typically the types of things that you need an expert to be able to do. So not real clear that she would, provide them with the means to be able to do that. But it is, at least in theory, possible that they'd be able to do that.
Hey, Lindsay, how you going, mate? Didn't Bowen read an objection, third-party defense into the record? And then Gull said, well, there's no nexus, there's no DNA. Didn't Bowen say, well, respectfully, neither is there for Richard Allen? Or did I dream that? Thank you for the 1999. And it's so good to have you here, Lindsay.
Yeah, this was quite a moment. This was at the end, towards the end of the case, when the state was making their offer of proof on the evidence that they had wanted to put on in defense concerning the third party culprit evidence. And Goal from the outset has just said there's no nexus. The legal standard to introduce third party evidence of guilt in Indiana requires a nexus between the perpetrator and the crime. And so this was just kind of an ongoing issue. Well, like, if this isn't a nexus, what is? Will you just tell us what a nexus is? And I think that's kind of, this is my recollection of how it happened, when she just says there's no nexus. And Andy Baldwin's like, well, how is there no nexus? And she's like, well, there's no DNA, and everybody. I mean, my jaw just kind of dropped, like, yeah, no shit. I mean, could we possibly try to be consistent with our application of standards just a single time? No, we can't. I mean, that question answers itself. But yeah, I mean, it's just, to me, this little interlude, it just spoke volumes about how there was never going to be anything that the defense was able to do that was going to satisfy Goal and allow her, allow them to be able to put on the defense that, in my opinion, they had every right to be able to put on. They more than adequately met that standard.
Hello. Hi. So we have a kitty cat here who's going to turn 20 this year.
Oh my goodness. Look at
He's a very old man. Yes, and there's some baby kitties over there. Hello. Yeah. Oh, the young'uns. The young'uns. Yes. Yeah, this is Seraph. And Seraph he doesn't take no for an answer. He was down there just going, rah, 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 rah. I know. I'm aware that you're there. And if I have to go and pick him up. Otherwise, he would just drive us all mental for the rest of the stream. So, hi, everybody. Hello. Yes, I know I'm here.
He
hi,
is precious.
Andrea.
Look at him.
He is very precious. He's mine. He is my cat. Yeah,
I can tell
he's always, yes, he's like, give me attention. Just give me attention. Oh, okay, you're right. And some guy with cancer. Hello, mate. How are you? Andrea, if I sue these people, will you represent me, please?
We're gonna have to talk to whoever you get locally to see if they can pro hack VJ me in, because of course I'm only licensed over here in Washington. But keep me updated, and we'll see what we can work out.
Thank you for the $4.99, mate. Now, Lara, who is AI and she's not real, says, does Helen know that the state asked for a 60-day extension and they want more words too? Yes, I know, and I have the motion here. Thanks to All Eyes who sent it to me. So let's have a look at that. We have, where are we? All up with the backs over here. We have it. Court of Appeals motion for permission to file an oversized brief. Yes. So Alan's brief is 113 pages long and raises, they want to raise that. By the state's count, there are 13 discrete issues, many of which contain multiple grounds upon which the error is asserted. Yes. So, hang on. Probably best if I share this. Yep. So
this was inevitable. This was always going to happen. It's really not unreasonable under the circumstances for them to both get more time in and get more length. So it's going to be granted. And
yes, fair enough.
It's fine.
Fair enough. Yep. Take your time. See what you got. And they also, where are we? So they want that, and they want just a file oversized brief, and they want more time as well. So yes, they want extension of time to file their brief up to and including March 17, 2026. Is that what it is? So hang on, is that how long they want? Yeah. They're requesting a 60-day extension of time. Yeah, okay, fair enough. Cool. Take your time, do what you must do. I cannot wait to see what they come back with.
Yeah, I'm very interested to see, because of course this is going to be different attorneys. These are going to be from the Attorney General's office.
Yeah.
You typically have a little bit of a different expectation of the level of just expertise and professionalism that you get at more of the higher level than you get from maybe the local elected, who's got a different set of incentives. It's going to be very interesting to see how they respond to some of this, what their take on it is, like how far are they willing to go to try to defend some of what happened here. It's going to be enlightening.
But there's something else to consider as well, and that would be, I remember you saying that the lawyers were out on the day that they were talking about his treatment in Westville. Is there some action that could be taken against the state corrections?
Oh yeah, so that day when the corrections officers were there, and there was just there was a massive number of people in the back of the room, looked like a bunch of suits, a bunch of I don't know who they are, but some of them had been identified as Indiana AGs. And so the state attorney, the Indiana Attorney General, represents the state agencies. And so the Department of Corrections is going to be a client of the Attorney General. And that's presumably, why they were there for that part of the testimony. as far as like, can there be a claim against the Idaho Department of Corrections? That's a super complicated question because it gets into what's the statute of limitations for claims like this, and that is not a straightforward question. You might think it is, but
no.
The federal civil it would be a federal civil rights claim, and they have this very complicated way of calculating a statute of limitations where they look at state law and say, like, what's the closest equivalent state claim to what it is you're alleging took place here that violated federal law, and then apply that statute of limitations. So it just kind of depends on what that is and what the circumstances are. But my understanding is that they might be past that deadline at this point. It just depends. Like I said, that stuff gets very complicated, but it looked to me like a pretty obvious claim. I mean, DOC had a policy, a very specific policy about how to handle inmates who have vulnerabilities, serious mental illnesses, specific limitations on the length of time that they can be held in solitary confinement. They very specifically did not follow that policy with Allen. They made an exception of him, and so seems pretty clear. Oh, and that policy had been adopted in the first place arising out of litigation that dealt with the First Amendment, with cruel and unusual punishment that was being asserted by the prison inmates who had suffered this, and so, like, it's already implicating their constitutional right to not be subjected to inhumane treatment. So. Yeah,
I would think that it wouldn't just be because of his own mental health situation. I would just have thought that it'd be everyone's right to not be treated to to have that kind of punishment or treatment, like regardless of your mental health situation.
Yeah, you might think, but the law is really not favorable on those types of situations. They don't like to tie anybody's hands. They don't want to make rules broader than they have to. So in the case of Indiana, that was just how their specific policy was written. It was very narrow for this context of dealing with people with serious mental illness. Richard Allen qualified. It certainly makes sense that, like, solitary is still torture for other people. But that was kind of ultimately where they settled, because they don't want to have to say, people can't be held in solitary for extended periods of time, even though there's ample, evidence about the, severe psychological detriment that inflicts on people.
Absolutely. And one thing that really bothers me about some commentary that's getting around, and this is all over the place, is that he only to say that he was only confessing that the confessions happened outside of the time that he was receiving Haldol, or that he was
flat not true.
That doesn't even matter. Like, okay, so some people start confessing when they've been just in a prison cell for a few days, or just having been hounded by police officers who keep yelling at them and putting gruesome photos in front of them for like 36 hours, depriving them of cigarettes and food and taking them away from their family. Some people can't hold out for more than a few days of that. He held out for months before he started to break. It's not just a matter of having been injected with these drugs. It's not just a matter of when some prison psychiatrist decides that he's having a psychotic break. This man was put into a tiny, tiny cement cell, deprived of any interaction with his loved ones, and just absolutely just put into this situation that's so far outside of what any of us would consider to be normal. And he then started to say all sorts of things, not just that he killed these two girls. He said all sorts of irrational things. And he did that over a period of time. And then people justify that as, oh, but he started confessing long before he was psychotic, long before he was given these drugs, and then long after. Well, who cares? How would you? I'd like to see how you would handle that.
Well, I mean, that's the thing. I think a lot of people who kind of minimize solitary confinement, they wouldn't last 3 days.
No.
You know, it's very hard to overstate the effect that solitary confinement has on people. And see, it's kind of easy to imagine it in your mind, you know, and you imagine it as like, you know, just not really that bad, and how I'd be able to occupy myself and yada yada. But there's things that you don't really take into account. So when you're in solitary confinement, typically you have no circadian rhythm. You have no natural light. You've got fluorescent lighting. It's typically on 24/7. So that can be a real big issue, because you lose track of time. There's a lot of noise often in these types of block, like noise echoes through, and so that can be sleep disruptive. A big part of what can drive you insane in these situations very, very quickly is just sleep related. Sleep deprivation will literally kill people. It will literally kill you. It is lethal. So there's just an enormous effect that alone has. Then you get into the lack of any kind of interaction. You know, or just minimal interaction, like 1-2 minutes during a day when your food tray is shoved in the door, you know, and the rest of the time it's you and your thoughts. It's just you and your thoughts. And, you know, you can't really put yourself in that situation, because most of us have never had to be in that situation. But the torment that it becomes to just, you know, occupy yourself and have something to allow time to pass. There are all kinds of stories that people who have endured solitary confinement have told about, you know, ways that they found to try to occupy themselves. And so, like, what that ultimately amounts to is that it's a major turning inward, right? If there's nothing but your own mind to put you through the day, then that starts to be what you focus on. And that can become, you know, real entrenched and real habitual real fast. You know, it doesn't necessarily take more than, you know, a week before you have done like so much introspection, and you've gone to so many weird places that, you know, being able to kind of snap back out of that isn't really a thing. So, I mean, I've had a lot of clients who have spent time in solitary. Nobody ever this long. Our standard over here in Washington for disciplinary is usually about 10 days. Can go up to 30, but that's not typically very common. And even just these short stays, you know, the effects that people report are really significant. And I mean, I don't mean just report, like you can see it on them. You can see it on, you know, how their skin becomes, you know, sunken and like miscolored, and their hair is like lank, and their, you know, behavior, they're like overstimulated once they get into that setting.
It's really
just minimizing it just tells me that you have you're relying on your imagination, and your imagination is really limited.
And this is very interesting, because you can hear it in his phone calls. You can hear the change in his voice. And if you didn't actually hear those phone calls, if you were only relying on someone telling you about the phone calls, then you might dismiss that also. And luckily we had you to tell us about those phone calls, and you told us too. I remember when you reported back about what you heard from the court, that he sounded very, very strange, very Bacon, I think. So I can't remember your exact words.
He sounds spaced out, kind of like, yeah.
Yeah, you did.
Real out of it. He sounded real out of it.
Thank you for that. Thank you for that. Yeah, you reported on that. It was you. I remember you sounded. Well, you're traumatized every day, really, but it was one of the harder days. There were lots of hard days, but that was one of the harder days.
Yeah.
Okay, guys. I'll answer a few questions and read out a few super chats and stuff, and then I'll respect your time. Thank you so much for being here, Andrea. You're amazing.
Anytime, girl. Yeah. Anytime. Yeah. I appreciate so much all the help that you were during this whole process, like keeping the chat going. And like, I mean, there was no way I was going to be able to keep track of the million things going on to make all this
I just wish
happen.
I could be around more. Like you stream so much during the day or when I'm on, and I'm like, I wish I could be in your chat more. It's
I
like,
know. The Pacific Coast, I've discovered, is like the absolute worst place for streaming because the only people that can like really watch me are Hawaii. You know, everybody else is I'm behind all the trials. I got to get up super early in the morning to watch the East Coast trial, and you know, if I stay up late at night, I might catch some folks in the UK, but that's like real late at night. So it's just
last time,
you know, it's my fault. I take my time being over here in the Pacific time. Maybe I really do need to move to Chile. You know, I can just always hold that. That was a great schedule when I was in there.
You do like Chile, but last time you streamed at my daytime, it was like it was like 1 p.m. and on a Sunday afternoon, and I had promised my mum I'd take her out for Christmas shopping, and I was like, no. Every other time it's been when I've been asleep. Like, no. Cat,
no. The Krakens have awoken. I think they had a little nap time, but now little Lilith is going to check in because I think she wants her dinner.
Hello, we've got Kat with us, 5 excited utterance memberships. Thank you so much. And Kat says, thank you for a great and thought-provoking show. Member for 18 months. Thank you, Kat Not Williams. Everyone, make sure you subscribe to Kat Not Williams. She's doing fantastic work. She's been covering the Zachary Adams bid for a new trial, which is really interesting, by the way. I don't know if you've been
catch up on that. I've heard that it's one worth looking at, and I haven't had the time yet.
Absolutely. It does look really interesting. And I feel really bad that I haven't been following that. So again, same. I need to catch up on it too. Sonia K says, will you guys trust the appellate court's decision, whatever that may be?
Trust the decision. I don't even know what that means. You know, as a lawyer, I'm going to look at it critically like I would look at any other legal decision. The fact that it's the appellate court doesn't mean that that they get everything right. It means that they're authoritative unless and until the Indiana Supreme Court decides to do something else. So I'm certainly going to respect the process for what it is. But am I going to just, accept the opinion and not look at like whether it's valid? No, of course not.
Very good answer, Andrea. And Chuck Anderson's granddaughter, hello, thank you for the gift of membership. You're always so sweet. And new member as well. I'm pretty sure you're already a member, but thank you for that. Thank you for that. And whatever clever, $1.99. If he requested bench trial, Gull be conflicted off.
No. I don't know what Indiana's rules are for disqualifying a judge. Like some courts, like my jurisdiction, you can disqualify one judge off the case for no reason at all. But you have to do it early on in the process. Once they've started to make decisions about the case, you've lost your right to do that. So I don't know if they have something like that in Indiana, but I would suspect if they do, it's probably too late. And unless there's maybe something like a change of counsel, but then it's also complicated by the fact that she was appointed by the Supreme Judicial Court. So she's not just like the one that was automatically assigned. They've already picked her out and given her the case. So there is no way that they would agree to a bench trial, unless they've already had the judge changed because of the high likelihood that she would be the judge.
Yeah, she's been around a long time, and she's actually really respected in Indiana. Like, she's not like thing with Judge Gull is we who've been following this and can see what's gone wrong. We have an opinion of Judge Gull, but then there's the other Judge Gull who has this very high regard in Indiana, right?
Yeah, she's been in the system for decades. She's got the connections. She's served on the committees. She's very well connected in the community of judges.
Very, very. She's been around forever, and she is she's right up there on. She gets like awards
have to kind of remind people hypothetically to consider, psychopaths, they're really good at putting on masks. They're really good. Ted Bundy knew how to turn on the charm and get people to get into the van. Judges, lawyers, doctors, senators, CEOs, people in positions of power is attractive. Power is attractive to people who are power hungry, and people who are power hungry aren't going to necessarily, have the same kind of emotional and ethical kind of interaction with the world that us, non-power seekers are going to have. So I have, been pretty clear about my opinion about Judge Gull and where she fits into that kind of ideology. But the thing you have to bear in mind is that she's not going to be the only judge that's like power hungry and there because they like their position and knows how to play the game and put on the mask and stuff.
That's absolutely true. And people have said, oh, surely she won't be like reelected or anything. Yes, she will.
I don't think she's got an opponent as far as I can tell.
She's been reelected for years and years and years. Why wouldn't she be reelected? And the thing about judges like this is that they seem to be doing a good job because they're putting away bad guys all the time. And people love that.
Yeah, they do.
People love that. Yeah, they do. So they don't see these things. People don't see the fact that they are not making any argument for their decisions. Like they're just making rulings and not even putting any thought, but they're putting thought into it, but they're not writing it.
The overwhelming majority of people who cast a vote for judge have never gone and sat a single day in the court in their community. This is just not, it's not a familiar context. It's not something people understand. Judges, when they're elected, are typically nonpartisan, so it's not a simple like party choice type of thing. You just kind of go with the name recognition is the most common way. And so somebody that's been on the bench for 28 years, I think it is going to have that type of recognition. People don't know what to vote for in judges. I can't even tell you how many times we elect all our judges in Washington. I can't tell you how many times it's election time and people call me up, Andrew, who should I vote for? There's no real clear reason why or knowledge about it or anything like that. So I continue, like I say over and over again, if there's one thing I can encourage people to do, if you're interested in these types of issues, is take an interest in your own local court. See what's going on. Go down, sit in on a docket, check things out, see who the personalities are, see how things are being done, see how they interact with each other. It's going to tell you a lot about your community and the culture of what's happening in your community. If you see people working well together, and things being done, pretty fairly versus you see, somebody acting tyrannically and, just other problematic types of behaviors.
That's interesting. The Indiana Supreme Court ordered Gull to cite case law in a death penalty case. Was that the guy who was executed in December last year?
Might be.
Because that was the first one executed since 2002 or something. It was a long embargo, and she could have stopped it actually, but she didn't. Yeah. Yeah, she was the last one who had a say over whether it could be stopped, and she decided not to. So even though the family were against him being the family of the victim were actually against him being executed, but she was like, no.
Yeah, I think I remember that.
Yeah. I did a little stream on it because it turned out because it was a family incident, and the family had decided that no, we probably don't want him to be executed, but she's like, oh well. Yes, there you go. Yeah, the victims were his own family. Yeah, that's right. Yes, that's right. It wasn't when it began. It was the end. It was around the sentencing, time of the sentencing. Yeah, December. Yeah. Anyway, yeah, lovely lady, girl.
Charming.
She's just she's a bastion.
She's
of
a
the
special
community.
one. She is a real special one.
Yeah. Anyway, Kim Jong Bev makes Kim Jong Bev look like a saint. Yeah, exactly.
Yeah, she does.
All right. Unless anyone's got any other questions for the lovely Andrea, we're going to respect her time and say thank you so much. When the state responds, I'm sure you'll be doing the rounds around then, and we might, if you have time, invite you back then.
We will make time, 100%.
Lovely. And guys, I just want to say that Andrea is just the most classy person. I always say, I've said this before, and I don't know if you've heard me say it, if I'm ever wondering like how to handle a situation, if there's some like drama or something like that going on, or if I'm not sure how to handle something, I think, what would Andrea do? And I really do. I think, how would Andrea handle
Go to Patagonia and walk around for a while is going to be my recommendation.
Yeah,
to pretty much
exactly.
Like 99% of the world bills.
Should I comment on this? Like, should I get into this thing? And I think, would Andrea do this? And if the answer is, would Andrea not, or would she? Then I go, I'll take the Andrea route, and it's always right. It's always right. So thank you for being just like, not just a great person, great commentator, great lawyer, but just a really good role model, and for all of us, I think. So
thank you. I appreciate that. That's big news for me to walk around in, but
I'll try not to let you down. So don't mess up.
No pressure.
Except for that time that you got like hooked on crypto. There was that.
Oh yeah, that was an issue. That was my bad. Yeah, I lost everything. Sorry about that.
Yeah, there was that. But there was. But when the thing is though, that when people say I got hacked, because I got hacked, we can say it's never hacking except when it was Andrea. It's never hacking except it was Andrea.
I will never post random crypto stuff ever. You have my word for it. Here I am on record. So
the only person who ever got hacked was Andrea.
Yeah.
I got hacked and extorted. No, Andrea got hacked.
We can't have Robert Devine like getting hacked everything everywhere for like 5 years. I think he might still be hacked. I'm not real sure. It wasn't real clear from his testimony.
And you were gone for like 3 weeks. It was ages. It's like, when are you coming back? Like, I'm pretty sure she's still hacked. Actually, it wasn't just you. Wow. Amanda Knox.
I saw. Yeah, I saw. Yes. She's got an issue with her DMs.
Yeah, she also really got hacked. Yeah. So you and Amanda Knox.
Yeah.
Can you plug a meme coin for Andrea? Andrea coin to the moon.
The Holman and McClellan kissing coin. We might be able to make that.
Please. Please. All right. Thank you, guys. Thank you, everybody. Thank you, Andrea. Thank you to all the kitty cats. And it's time for the song. It's time for the song.
Her name was Ella. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud and because she's an 803. To the attention, excited utterance. Her cat is staring from